Well, let's bring it all together with a summary then. Let's briefly review contractual remedies and think about the analytical flow you might use when determining what remedies should be granted. First, you must determine whether a contract was formed. If there was no contract formed, or if the contract is not enforceable, then remedies at law are not available. You cannot have breach of a contract that does not exist. Instead, a party who relied on a promise may be able to recover reliance damages in equity. And if one party conferred a benefit on the other, but was not compensated, the doctrine of unjust enrichment may allow a party to recover restitution damages in equity. Sometimes these remedies of reliance and restitution are called quasi-contractual remedies, but they're generally used only when a contract has not been formed or a contract is not enforceable. Now, let's talk about what remedies are available when a contract has been formed. Sometimes that contract itself will provide remedies in the case of breach. When a contract provides its own remedies, those remedies are called liquidated damages, and courts will require a breaching party to pay liquidated damages unless they are so unreasonably disproportionate that they constitute a penalty. Remember that courts will not grant punitive damages for a breach unless the breach is so egregious that it is also a tort, because sometimes breach is efficient. If the contract does not provide liquidated damages, or if they are to be set aside for being an unreasonable penalty, courts will generally award expectation damages, which are equal to the loss in value plus the other loss minus loss avoided. Expectation damages, including consequential and incidental damages, are limited by certain things such as foreseeability, causation, and the duty to mitigate damages. In rare cases, such as when expectation damages cannot be reasonably calculated, or when performance is for land or an otherwise unique item, a specific performance or injunction may be appropriate, or courts may award restitution or reliance damages for breach of a contract at law when expectation damages cannot be proved. Finally, courts may require a party to perform or not to perform, but courts only grant specific performance or negative injunction in a few narrow types of cases. Courts will generally grant specific performance or negative injunction with respect to sales of land and unique goods. Courts will generally not grant specific performance or injunction with respect to contracts for personal services, although covenants not to compete may result in a negative injunction if that term is reasonably limited in time, geography, and industry. That concludes our discussion on contract remedies. Any questions on contract remedies?